Hey everybody, welcome back. I'm finally back. I thought I was going to be back a little bit sooner today, but welcome in everybody. And see, since I kept pushing my time up, everyone's probably like, is Tanya really live? Is this really happening? And I did a morning live today too. So I really probably messed with you guys a bit today. So sorry about that. Especially if you're signed up for all the notifications, you're probably like, is Tanya drunk? Because it looked like it. I kept kind of pushing the live out further and further because I didn't want to come on and them not be tweeting or anything, you know, and then we're just kind of looking at each other. Well, I'm looking at the camera and you guys are just looking at me. So I figured I'd wait a little while. And then I knew that, you know, the court TV would come out with their tape. So I was like, we'll just wait. So we're going to talk about Idaho. If you didn't know already, it's in the title. And maybe I don't think the title will change tonight like it did last night. If you watched last night's stream, you're probably like, Tanya's really drunk because we did half the stream Idaho and then we switched over to the mass shooting that was happening in Maine. So it's crazy. So basically today they went over and you know what? I actually took out all of my notes. I wrote down every single note that officer spoke at that press conference today. And I went back over it all in the live, but they said that 13 people were injured, 18 people killed. It wasn't the 22 people, you know, that they thought. And then we thought there was 50 to 60 people injured last night. There was only 18 people or 13 people, injured. They couldn't really answer a lot of questions. They kept saying like that, you know, leads to motive. We're not going to go over that right now. We don't have that answer right now. So on and so forth. But we did get a little bit out of them. So it was a pretty good live. And my cheeks feel so warm. So if I'm flushed tonight, I don't know why I am. Probably because I just took a really hot shower. But at least I smell nice and good for you guys. And welcome in, everybody. I'm going to go back up to the top of the chat a little bit and see you guys. Because I was like, man, Mr. Rosebud was in here. Hopefully he comes back. Everyone's probably like, oh my gosh. We were talking earlier in the day. Let me get back down to tonight. I'm like all the way back till today. Let's see here. Yeah, Jan, you did send me a text. You did. I was like, I had to go to, well, I didn't have to, but I wanted to. So I wanted to go to Home Goods tonight. And I didn't even end up getting anything there. I went to Home Goods and I got dog bags, like for their poo. That's not what I wanted. It's not what I wanted. I went for dog beds, but they didn't have any. They didn't have a dog bed or a cat bed I wanted. So we came up empty-handed because I could have just picked one, but you know, I want to get them something that they're going to love. So, and I haven't been able to do that just because, you know, we usually go live and I wanted Vincent to go with me. So, and he works till late. So I was like, I'm just going to sneak out tonight and do it. Yeah. I wanted to get them dog beds. And the cat, a new cat bed. I'm weird. I'm a weird dog, crazy dog mom. I like to get my animals things. It makes me happy. That's what brings me joy. It does. It brings me joy to like give them stuff. I actually had the dogs in here earlier today on the live. Well, I had one, Mia, but I tried to get the other one to come in. She wouldn't come in for nothing. So that's okay. So earlier, like I said, today we did a live, but we were going to come back and we were going to do Idaho stream. When Bryan went to court, we were going to go just go off of, I was going to go off of like Bryan Enton's tweets, because that's usually the person that gets in first. And he usually tweets very fast. So you're not like sitting there with open air, like, oh, wait, like, wait to see when he's tweeting. And then, you have like empty air and you're just like waiting to see. He's usually really quick at like filling those time space in. But he had tweeted out and he said, sorry. He said, hey guys, we might, they may ban our phones and our laptops from inside. We might not be able to tweet if I go silent. Like that's why. And I'm like, so I was like, what do I do? So that's why I kept pushing the time forward today. If you were wondering, like it went from like 3:45 to like 4 to 4:15. And then I was like, I don't think that they're going to tweet. And then as soon as I literally changed the time, that's when they were like, oh, we're going to tweet. And I was like, really? But we would have been sitting here for like 10 minutes at a time with like nothing to go off of. It would have been excruciating, I feel like, if we would have been doing that, because, we would have wanted to know what was going on. So before we get started with Kohberger tonight, I was just going to point out a couple things that I saw from the victims' families, and I thought that that'd be a good way to start the live off. So I didn't see anything, from Maddie or from Xana's family, but I did see a couple things. I saw something last night, which I have a video coming out over tomorrow, and then I found something tonight. So the first thing was, Kaylee Goncalves, her family is very vocal in this. And they put today up on their Facebook, which the post is kind of small. Sorry about that. I should have blown that up for you guys. I didn't realize it was that small. But it just says, court today, please pray that things are decided in our favor. I can barely breathe. We have been waiting for this day since September 20th. And I think that they got the decision that they wanted today. And I'm happy for them, because last time they were in court, they weren't so happy when Kohberger, decided to give up a speedy trial. So I just wanted to show you guys that. And then I have something really, really cute to show you guys. So I subscribe to the Idaho Statesman. I don't know why I do that. I need to cancel that $20 a month that I give them, because these are free. Like, I'm like, I can just read these for free, I think. So I wanted to read this to you guys because this was very, 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 very sweet. So basically what I'm going to read for you here, I think there's a title up here. Sibling received scholarship in memory of brother slain in University of Idaho stabbing. So this is going to be about Ethan and his brother. Nearly a year after Ethan Chapin and 3 other University of Idaho students were killed in an attack near campus, his brother received an award created in his brother's honor. And this is going to be the scholarship that we're going to talk about. Hunter Chapin received the inaugural Ethan Chapin Memorial Scholarship from the Sigma Chi Foundation at Wednesday night's Sigma Chi Fraternity Scholarship Dinner. Both Ethan and Hunter were members of the fraternity. The award is intended to go towards tuition and honors the Idaho Sigma Chi member who best exemplifies Ethan's character, his enthusiasm for life, and his smile for everyone around him. I don't think there's anybody better to get the award, really. I mean, it's his twin. It's like a part of Ethan. The organization said the endowed scholarship will give $5,000 to an Idaho chapter member each year. I'm honored to be receiving the first Ethan Chapin Memorial Scholarship, Hunter Chapin said in their release. It makes me feel so happy to see the Sigma Chi's around the world honor and care for the undergraduates. Chapin, 20, was a freshman when he was stabbed to death on November 13, 2022. His girlfriend, Xana Kernodle, 20, and her roommates, Maddie Mogen, 21, and Kaylee Goncalves, 21, were also killed in the attack at the woman's off-campus home on King Road in Moscow. Bryan Kohberger, a graduate student at the nearby Washington State University, at the time has been charged with their murders and is awaiting trial. Maisie Chapin, Ethan's sister, helped present the award to her brother. The Chapin family was the fund's largest donor, some of which came from Ethan's checking account. That got that got me in my feelings earlier when I read that. So some of the money that went to this scholarship was from his own checking account. So his parents, instead of, keeping that money, or, maybe just saving it, I don't know what you would do with it, but they took that money, whatever he had in his bank account. I don't know if it was $1 or $5,000, but they took it and they put it towards the scholarship. Like, to me, that got me in my feelings earlier. So you'll see it on the video tomorrow, because I didn't read this before I did the video, and I was just like, whoa, I shouldn't have done that. I usually read everything beforehand, but I was just so excited. I was like, I'm going to make that video really quick, because we had some time today since we didn't have the hearing so soon. So I just thought that was extremely nice. The fund has since garnered $125,000 through donations. Sigma Chi said if the foundation receives additional funds, the $5,000 amount will increase for future recipients. It was breathtaking to see hundreds of people from across the hemisphere immediately step up to support the Ethan Chapin Scholarship as a way to make a statement of goodness and love. Jeff Burnside, Sigma Chi Foundation Director of Development for the Northeast region, said in the release. At the dinner, fraternity members unveiled a plaque featuring Ethan Chapin's name and face that will hang in the Moscow chapter house. The organization said it hopes the gestures will help future members remember their slain brother. Let all generations honor Ethan and strive to be like him, the ending of the plaque states. Those interested in donating can do so through the fraternity website. I just thought that was really nice. And it says on here, the plaque, it says the Ethan Chapin Memorial Scholarship is awarded each year by the Sigma Chi Foundation to the Gamma Eta brother who best exemplifies Ethan's character, his enthusiasm for life, and his smile for everyone around him. Ethan was tragically taken from us and entered the chapter eternal on November 13th, 2022. Let all generations honor Ethan and strive to be like him. I thought that was really sweet. I was like, that's a good way to put the money, to put his money. I think that he would. I think that if Ethan was alive, he would have liked the plaque. I'm pretty sure that when they probably walked in the fraternity house, there's probably a picture of somebody up, somewhere that is head of the head guy, and they're probably like, I'm going to be up there one day. You know what I mean? Says that, but they don't really think that they will be. So. Is it, Cheryl? It's coming up. Wait, no. I thought his was in July. Or no, it's October. You're right. I know that Kohberger's is in November, I think. But I think you're right. But I did my nails for him, I thought, for the birthday, but it must have just been for the tulips. October 30th was the day that my mom passed away. That's why I was like, what? Really? That's different. Yeah, I know that Xana was July, and Maddie, I think May. No, I think May and June is Maddie and Kaylee, and then Xana. Wow. Yeah, we'll have to see if that's the date. I know that I believe it was coming up. Yeah. I didn't mean to do that. I wanted to share this with you guys. No, actually, not this one. Sorry. Just kidding. No, actually, this is the one. Okay, I wanted to read this to you guys. I wanted to pause this little video. They always have that planned. So before we get into the tweets and everything, I was going to read over this for you guys. That it just kind of gives us a summary of what happened today. But Bryan Kohberger, if you're not aware of who we're going to be talking about, that's who we'll be talking about. Also, if I didn't tell you guys my name tonight, I'm telling you, TitaniumBuilt. Welcome to the channel. I think we just started talking Idaho, didn't we? If you guys wouldn't mind just taking a second to hit the like button, subscribe to the channel if you appreciate the case coverage. We're all over the place tonight, but what's new? So Bryan Kohberger returned to Idaho court today for a set of scheduled hearings in which his lawyers were going to ask that the indictment be dismissed and that the case be sent back to a smaller court, for a preliminary hearing. One of the day's hearings was open and then one of them was closed. So this morning they had a hearing and it was closed to the public because they were discussing grand jury, details, and they can't really allow those things to be out because they're secret grand juries. So they had that in private. And then this afternoon, they were supposed to have their 1 o'clock court hearing, which would have been 4 p.m. Eastern Standard Time. But that one started a little bit late due to the fact that the first one, the morning one, lasted so long. So I'll read through this article and it'll give us a little bit of a better understanding of what happened today, which I've watched the video, I think twice now, almost. I listened to Jay Logston twice and I wasn't impressed. I wasn't. I was trying to be, but I wasn't. So this is from Creme 2 and they're local to Idaho. So I like to go to them for, to get some of my news because they are so local and they've been covering this case, pretty extensively. So it says it's been almost 6 months since a group of Latah County residents indicted the man accused of murdering 4 University of Idaho college students at an off-campus home. Now his defense wants the group's decision thrown out. Ultimately, that won't happen, at least not for the reasons presented during Thursday's public hearing. Bryan Kohberger appeared in Latah County Court Thursday for a hearing on his motion to throw out his indictment on the grounds of error in grand jury instructions. The defense, state, and judge argued about a precedent previously set by the Idaho Supreme Court. Ultimately, the judge said he couldn't do anything to change existing laws and denied the motion. He actually said some pretty fun. He actually had a pretty funny comment, I thought, and I'll read through Brian's Twitter. Defense attorney Jay Logston presented Kohberger's argument in court Thursday. He said grand juries are hard to control and will likely indict a suspect on their accused crimes. However, he added status were created to rein in grand juries and prevent prejudice against a suspect. Well, thank you, Jan. She's gifted 5 memberships. Look at that. Everybody's getting a membership. Thank you, Jan. That's so nice. Oh, that's so sweet. Well, thank you. Look at that. I love that. I always want to hit the allow gifts. I'm like, don't do it though. I'll be taking it from someone. Because I see it and I'm like, oh, I want a membership. See, they're that good. They're that good, guys. It's making me even want one. Logston said the defense takes issue with the burden of proof presented to the grand jury. He argued the standard of proof for a grand jury is beyond a reasonable doubt rather than probable cause. Judge John Judge stepped in at this point in the hearing, stating it's not fair to claim the grand jury was given false instructions if those instructions are standard in Idaho. The state added the Idaho Supreme Court has held probable cause as its correct standard of proof for a grand jury. It is essential to note an indictment does not mean a suspect is guilty. Instead, it means the grand jury has determined there is enough evidence against the suspect to convict them of their accused crimes at trial. Judge John Judge told Logston that while his argument is creative, he can't change a law previously set by the Idaho Supreme Court. For that reason, he denied the defense's motion. This is not the only motion to dismiss Kohberger's indictment. However, on Thursday morning, a private hearing was held to discuss the defendant's claim the grand jury was biased and shown inadmissible evidence. The defense also claimed the grand jury was shown a lack of sufficient evidence and claimed the prosecution withheld exculpatory evidence. The outcome of that hearing is under a seal and will not be released to the public. Not unless I get my hands on it somehow. Just kidding. How can we get in there? The outcome of that hearing, okay, I read that part, sorry. And then it just says, Kohberger is accused of killing, and we know who he's accused of killing. Kaylee Goncalves, Ethan Chapin, Xana Kernodle, Maddie Mogen, an off-campus house on November 13th, 2022. He was arrested at his parents' house in Pennsylvania, December 30th, and extradited back to Latah County in January. He's been in the custody of the Latah County jail ever since. I think that's just, at his arraignment, he just stood silent and had 4 not guilty pleas entered on his behalf. So I just wanted to give you guys a little update there. So basically, they ruled on cameras in the courtroom, and he said that he was allowing cameras to be in the courtroom. He was going to take more control over the cameras, and then he denied to dismiss the grand jury. Just denied that. So this is Brian Enton's tweeter. I don't know why I said it like that. Twitter, X, whatever you guys call it. I call it Twitter. I'm I'm just going to call it that probably forever because that's just what I'm used to. Like, look, even right there, add me on Twitter for up-to-date date. Like for up-to-date updates. I can't even say it. I've never say X. Let me see if I can blow this up a little bit. I didn't realize that it looks so small. Oh, look, I can. Oh, wow. Look at me. Look at me go, guys. Wow. Let's see. I want to make sure I go down. Okay. So there he is in his usual spot. This was 8 hours ago. It says, I'm outside the Latah County Courthouse. Closed to public. Bryan Kohberger hearing is happening now. I'll go in for the public hearing this afternoon. The defense has challenged the grand jury indictment. I'll live tweet from court this afternoon and have the latest on News Nation. And I don't know if you guys saw the picture of the inside of the court, like before you get into the actual like courtroom, but there was a line, like it was snaking around the corner there. There were a ton of people there compared to previous hearings. Today, I guess, was a really busy day. Yeah, so this is what happened today in court. This is what happened. What I'm reading now is what happened today. So it said, hearing seems to be delayed, still waiting outside to be let in. I thought he put something like if he wasn't. Okay, maybe it's up here more because he did put if he was quiet. That's because, all right, there it is. Okay, never mind. Hearing seems to be delayed. Like I said, still waiting to be left inside. And then he said, deputies says judge will allow cell phones and laptops today, but encourages everyone to follow the rules. No recording allowed. I know that he tweeted that. I don't know where it was at though. Oh, there it is. Deputies outside. Sorry, I read that kind of backwards, but deputies outside Kohberger's hearing says judge is considering banning cell phones and laptops from courtroom. So if I go quiet on Twitter, that's why. Hearing starts at 1 p.m. local time. So that's what I was seeing. And I was just like refreshing the page when I was talking to you guys in the chat earlier today. So I thought that was kind of, I was like, come on, are we going to be able to do this? So it says, I am in the court now. Bryan Kohberger just walked in. Hearing should be starting soon. Kohberger, judge says morning hearing was sealed because they were dealing with the procedures of the grand jury and there were a lot of details. Grand jury proceedings are secret, so it had to be sealed, he says. Kohberger judge reminds people who are not allowed to record. Kohberger judge reminds people they are not allowed to record anything in the courtroom. He says rules have been violated in the past. Someone was recording something. Kohberger judge says he will not ban cameras in courtroom, says instead he will take more control of the cameras. Which, what do you guys think that means? Do you think that we're going to get like a still shot, like where they're just going to sit it stationary, pointed at the witness stand? And then it has to be turned off when they approach? What else? What more can you do? Don't give us just audio, But I mean, he says he's not going to take them out though. And if you guys remember, both the prosecution and the defense were both like, we don't want cameras we don't want cameras. And the judge is like, no, we're going to have transparency here, buddy. So I'm liking that. I haven't seen Crazy for Books. I haven't. I know. We'll have to do another stream on that soon because they haven't caught him yet. I've been watching like all day. They were like in the woods. They're just like, there's just a camera just pointed there. I'm just like, it's like watching paint dry. I don't know if I thought he'd be on the boat, but guess not. So it says here that the Kohberger defense making argument now to throw out grand jury indictment. Defense is arguing grand jury was given the wrong instructions, but judge says it has been the same instructions given to grand juries for 100 years. I thought that was pretty funny. Prosecution is now arguing why Kohberger grand jury indictment should not be thrown out. There is nothing to see here. The Idaho Supreme Court has ruled on this issue. So, yeah. Kohberger judge denies defense motion to throw out grand jury indictment. And Kohberger court is adjourned. Grand jury indictment stands. And a decision we did not expect today. Judge said cameras will stay in courtroom, though he will take more control of them. And then I think that's all of it for Bryan. But yeah. We don't know if she heard from her other son. No, we don't know. I know I've been thinking of her too. She's like came in here. She was so nice. I hope that yeah. Can't record entering or leaving, need to protect his fly. Oh my Lord, what did I see today on Bryan's Girls? There was something on there. We have to go through. We're gonna have to go through that subreddit, y'all. I was laughing so hard. What did I see? I don't even know what I saw. Oh, y'all. You know, like the side, I don't know if I have that picture. There's a picture of Bryan out there, and it's like his side profile, and it's like when he's wearing the orange t-shirt. And it was a girl, she captioned it like, the first time I ever saw Bryan Kohberger, and I knew I was in love or something. And I was like, oh my God. And I was just laughing because it was so gross. All I could do was laugh. So that's what that reminded me of. PKC. Don't focus on his fly. And who the hell thought of that? I thought they were looking at his belt. I want a daily report on his fly during the trial. Doodlebug, I'll make sure that we give you one. We'll have a daily fly report. Bulletin board. Don't tempt me. I will. I'll do something like that because we got to do something to entertain ourselves on the days that, like, you know, somebody up there is just like excruciatingly painful to watch, you know, testify, because there are those days in every case. So they did release the video for Bryan Kohberger today. So we'll watch that. I listened to it without headphones and with headphones. I listened to it both ways. It's loud enough without headphones, but if you really want to hear like what's going on, like, you know, the details, I would probably put headphones on, and I can slowly turn the volume up. Baby Bryan posted that, did she? Ozzy, are you in that group too? Ozzy, are you in the subreddit? Let me know. Because, oh my gosh, I think that could be who it was that posted it. But I was just like, oh my Lord have mercy. Let me know if you're in that subreddit, because I am. I'm going deep. I don't even know how they even like, you're in there. Ozzy, I love that. We think the same. I was like, I'm going in deep. I'm going in. Now, you won't catch me like, you know, getting on Amazon probably and buying no like, you know, Kohberger knife or nothing, but going undercover in a subreddit that has to do with Bryan Kohberger, because there's a bunch of girls that think he's attractive. Every day I'll go in there and have fun. I gotta read. That's my reading material. I gotta read, I said. Oh, he's not back. Perfect timing, actually. Perfect timing. And so that's just funny. We're both in that subreddit. You have to like be approved now. And I was like, oh man, because they kicked me out. They kicked me out for a minute. I was so mad. I was like, they figured out who I was. But now I'm back in. So we back. Okay, so I'll go ahead and put it on. This is for the court. So it's like 45 minutes long. So I'll let it play like all the way through, because I'm going to pause it at a certain spot though. And we're going to listen to it again, because the internet is kind of already buzzing. Rumors are flying already. I don't know if you've seen them out there, but according to people online that like to, they didn't listen. They didn't listen all the way through, I don't think. So they're trying to say that there were 6 grand jurors that had questions, and they're making it sound like these 6 jurors were not going to say that he was, you know, that they were going to say guilty or like grand jury indict him. They were going to say no until they had their their questions answered. There were 6 jurors that had questions, is what people were saying. Okay. Well, if that was the case, that's not what Jay Logston said. He said there were 6 jurors that wanted more info. I know about 1.5 million people right now, probably, that want more info on this case. We all do. We all hear a little bit. November 13th, we heard one news report and we were sucked in like flies. Of course, they probably wanted more information, but they didn't say that. They didn't say they had questions and they weren't going to indict Bryan Kohberger, because you have to have a 16-person unanimous has to be all of them have to say yes, indict him, or they don't indict him. So I know the internet is breaking with that one. I don't know if y'all seen it, but it's breaking, y'all. It's broken. Like one person said it and it's spread like wildfire. They're even wording it the same way this person words it. Like they like copy and paste. I hate copy and paste people. I hate people copy and paste. It's like, I want you to watch the video, people. It's not you guys, but people that don't watch the videos. So it's going to be at 19:30. That's when they're going to talk about it. So I went back and I listened to this for the second time, almost the third time for Jay Logston, because I was like, I want to know when they say it so we can all hear it together, so we can hear exactly what they say. But the motion was denied. So I don't know. I guess we're going to throw the judge in there now as corrupt, because I don't know where people are going with it. But if you guys know, let me know. But thank you guys all for being here tonight. I appreciate it so much. If you guys don't mind just taking a second to hit the like button, share the content. If you'd love to share the content, we'd love to have you. And we'd love to have you do that. And we'd love to have you be a part of our channel if you'd like to subscribe. Also, I believe they got a new woman type in today. Not the one lady that was sleeping last time. Oh, actually, let me turn that down. Sorry, I didn't mean to do that to you guys with headphones. I'm so sorry. I'll turn it up slowly.
Okay. All right, let's get on the record, please. Thank you. We're now on the record. This is the state of Idaho versus Bryan Kohberger. Case number CR 2922-2805. You have that adjusted properly? Okay, great. Couple of things I just want to share. Number one, I apologize for the delay. We were supposed to start at 1 o'clock. The hearing that started at 9:30 went a little long, but it was important. You're probably wondering why it was sealed compared to this part of the hearing, and that is because we were dealing with the procedure of the grand jury, the procedures of the grand jury, and there were a lot of details, and the grand jury is secret. So that's why it's sealed, and whether you like it or not, it's baked into our United States Constitution and the Idaho Constitution. So there's a reason for that. I advised camera people not to turn on the cameras until I was on the record, and they turn off when the record is off. I just want to remind you, you just heard Matt talk to you about not having.
I know we're not supposed to be judging Kohberger because we might get the cameras taken out. Judge, if you're listening to this right now, I'm sorry, but I'm going to judge for a minute. His side profile is different. I don't care who you are. He's doing something to them eyebrows. They look better than mine. And I've been watching him for a year, for 11 months and like 2 weeks. Oh my gosh. 2 weeks tomorrow. So I know the side profile of that guy. That's a different profile. Did everyone go to the melting pot or something before the wax pot? That was called the wax pot before the court or something? Everybody got their eyebrows done? Their hair done?
Phones, your laptops to film anything, to record anything, that would be a violation of the rules. And we will take away your laptop or your phone. Some of these rules have been violated in some of our hearings, and I have an obligation to put a stop to that. And I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control.
Sir. I didn't hear that the first or second time. How did I not hear that? Sir, this is the internet. How are you going to stop people? I ain't going to do nothing. I'm not going to zoom into Kohberger's fly. You have no problem over here with that. But it's the internet. I think he's going to say that next, but that was just funny. He was like, I just got to control everybody else. Okay.
Control so much. And that's why I continue to urge people to be patient and have some dignity and some restraint.
Oh, dignity's out the window.
Some of that I've heard or seen has been disappointing. Just so you know, yesterday I issued an order addressing IgG DNA, and there's going to be an order.
Sorry, that reminded me of something. I don't want to interrupt him, but there was paperwork because Jan's awesome. I knew there would be paperwork that dropped after this court hearing, but it's long, but I'm going to go through it tomorrow. It's 30. One of the pages is 32 pages about the IgG, and I want to dig into that. So I wanted to tell you guys so I didn't forget, but because I always usually read the paperwork in the beginning, but it was really long and I didn't want to, bore everybody tonight. I want to be able to read it first, digest it in my head. That way I can give you guys, I'm not reading it to you, just reading it and being like, what does this mean? We know what it means. So.
For in-camera review, then I'm going to go through. In-camera does not mean anything about a camera. That just means I look at the information before I can share it with the defense. You see, what else did I want to kind of share with everybody? I think that's about it. So we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument. Thank you.
Hey, Gar. Well, as Your Honor is aware, I wrote a lengthy brief or two on the subject of where we're supposed to be legally with our grand juries and where we actually are. And as Your Honor let me know this morning, probably not going to change your mind because the Idaho Supreme Court has, I think the court thinks, gone the other way. So I guess I would accept that kind of ruling as long as the court agrees with everything else that happens.
Oh, well,
But
I don't know about that.
assuming that you don't, let's, I guess, just kind of walk through the simple steps here. So at issue in this particular case is Idaho Code 19-1107, and the infamous language in it that says that grand jury ought to find indictments and all evidence before them taken together, unexplained or contradicted, would in their judgment warrant a conviction by a trial. And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue. What warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s.
Don't know if you're hearing this or not, but he's talking about California law. Like already off the rip. We're in Idaho, sir. Well, I'm not, but you know what I mean. They're in Idaho. He should be reciting Idaho law, not trying to dilute things with a California law. Because then people don't hear that part and they're like, oh, that doesn't happen in Idaho, or that does happen in Idaho. No, he's talking about California though. So like, why are we doing that?
50s.
But he does look like Sam. I don't know. Sam Smith.
I
don't know where I got that, but I can't unsee it.
Probable cause, but they weren't too specific about exactly what it meant. And the state has pointed out that if you look at really old dictionaries, it looks like the word warrant means what you might think it does. The old-timey folks, as it does to us, that if it warrants doing something, it means that it would permit doing something. So the plain language seems to support what we're saying. And the biggest problem that I have then is just that obviously everyone in the country disagrees with me, from sea to shining sea. And so I'm now put in the position of trying to explain why that occurred and why in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer to that, other than I think the only time I ever heard about field codes before I was looking into this was like a really short moment in a class that I took back in law school. So, I mean, it's somewhat famously kind of the first attempt to codify the law of the day. It takes place in New York and spreads across the country back in 1850. And I think what I read in the tea leaves from the New York decisions and the later California decisions is that there was pushback at some of the things that the field code was trying to do. And one of the things that the field code very openly said it was trying to do was fix the grand jury system. Because the grand jury system was believed to be essentially broken. For a lot of the same reasons we don't seem to like grand juries very much today. It was essentially believed that grand juries were hard to control. Grand juries would essentially always favor whatever it is they were told and would always indict the accused. And so as a system to protect people, it didn't seem very protective. And they pointed out in the field code, if you go back and read it, that essentially the secrecy aspect of the grand jury is both its most powerful sword and its kind of its worst aspect at the same time. Because you just don't know what you're going to get out of it. And so they create a bunch of statutes that start to rein in what grand juries can and can't do. And they create some scenarios under which grand juries can be reviewed. And they, in the New York, they call it their Court of Appeals, it's their Supreme Court, says, even though we have these statutes that say we should only set aside these indictments in these particular moments, clearly there's got to be some sort of a due process protection. If you're going to pass a bunch of statutes that rein in a grand jury, you can show that somebody's not following those to the prejudice of the accused, and that's going to look for dismissal as well. And that doesn't seem to be very controversial. We see similar language in that Gaspar case that we talked about in the state of Idaho, which I think dates to like 1913 or something along those lines. But at the same time, while the state of New York is trying to figure out ways to not have to abide by the language of what would warrant a conviction, by essentially saying, you can tell the grand jury that is their burden, but you can also tell them the probable cause thing, as long as they hear both of them, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. That kind of moots the whole situation that they've obviously fixed it by statute. Our situation is such that we have this thing on the books, And the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, when they finally say, look, we passed a rule. I hope it's clear now. Stop saying that your burden is beyond a reasonable doubt. Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties like me in the legal community go and are selected to sit in a room and decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court will later have an opinion and go, this is weird, why is this one more rules? And so to simply say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly the Edmonton court was behind that as a concept. At the same time, nobody was arguing with them about it. Nobody argued about it, the issue, until just now. Well, that's not quite accurate. Obviously, Mr. Nosco raised this in a few district court cases up in Virginia. But nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it. And they said, no, you're wrong, it's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones. And the fact that they adopted a rule that says something that they believed doesn't necessarily set in stone what the law is, or for that matter, what the Constitution has to say about it. So the big issue, I think, at least my favorite issue here, was can the Idaho Supreme Court override the legislature and lower the burden of proof for the matter? And that was a tricky one, because we don't really have a case that just comes out and says that the burden, or for that matter, I guess I don't know, we got this all kind of mixed up when we were doing the
So we got this all mixed up.
I think we decided it was actually who has to show something, and then it was the standard of proof is the amount that has to be shown. But everybody confuses it all the time, and I'm confusing it right now as well.
See, I'm confusing it right now as well.
But I'll call it this.
He's like, oh, I'm confusing, but nope, let's deflect. But, and then he goes into his next thing. I don't know if I like this guy very much, but he does remind me of Sam Smith. I don't know why. Look at the hand. Maybe it's the hands. I think it's the animated hands.
The standard of proof, just to be less confusing. In any case, the standard of proof is that something that the judiciary has power over. In other words, is that simply a procedural rule, or is it a substantive rule of law that courts can't mess around with? And we argued, it cannot be that if the Supreme Court woke up tomorrow and declared that the standard of proof in our cases was something beyond reasonable doubt in trial cases, that we would also say, oh, well, that's what the courts get to do. Because if you read those cases, what they talk about is that is a right, a due process right, essentially, of the accused that is set by the Constitution, right? That's what In re Winship is. It set the standard via the Constitution, locking in the standard of proof that's required for a conviction. And so when we talk about these standards of proof, it is true, obviously, that if you look through the case law, you'll see courts setting a standard of proof for their own evidentiary rules. But you don't see it in many other places. What you see them doing instead is having somebody come in and say, well, the legislature set this standard of proof, but we think you should make it higher or lower based on, and almost nobody ever says lower, it's always higher. And we're always arguing that the Constitution clearly must set it in at some higher point to protect people, and then the courts lean in and say, well, we don't see any particular reason why the legislature messed this up, or if you're in the United States Supreme Court, occasionally you say, well, we do think that this is goofy and we're going to raise it. Okay? I couldn't find a case where the Supreme Court or anybody else leaned in and said, we think that the legislature is being a little too protective of its people here. And we're going to move down the standard of proof for the government in this particular case, or one party versus the other. Typically, in this country, we try to protect the accused, and we believe that those protections are given to us via the Constitution and via these concepts of due process that come to us with common law, which is where this gets so messy, because the common law would tell you that it's probable cause, and it's some guy named Field in New York who's telling you that it should be something else. Well, we could get into all of that, but it would be, I think, more philosophical than anything else, because the state of Idaho didn't do it that way. The state of Idaho, as a territory, adopts a bunch of codes out of California, a code that they've already looked at, a code that they've already said, these words clearly mean something more than probable cause. This is what you're adopting. If you come and get it, the state of Idaho goes and gets it and adopts it. So that's what the state of Idaho is adopting. I obviously recognize that the founders that wrote the Constitution did not appear to recognize what was already on the books in this regard. However, just because they didn't recognize that doesn't mean it's not still part and parcel of what was thought to be true by a large portion of the citizenry of Idaho, who are the actuals who ratified the document. The only thing we know is that from 1890 to Edmondson, the Supreme Court of Idaho was repeatedly admonishing prosecutors to stop using a beyond a reasonable doubt standard for a grand jury. And that, it seems to me, is pointing to this concept. I mean, if we're going to talk about common practice, the common practice looks to have been that everybody thought that the standard for the grand jury was beyond a reasonable doubt. And I don't think this is like worthy of the grave nightmares that I've been reading about. Obviously, in each one of those cases, the prosecutor was able to pull it off. And little wonder, I mean, it's still a grand jury proceeding. It's still just the prosecutor in a room with 16 citizens, 12 of which have to agree. They get control over basically everything that's being put on. I mean, the guardrails being put in, hey, let's use admissible evidence. Hey, let's not pull in hearsay witnesses. That kind of thing is not going to somehow make this impossible and make it so that it can't possibly work. What it's intended to do.
So right here in the next 30 seconds, he's going to start. This is where he's going to talk about the 6 grand jurors that had, they wanted more information or something on the case. The way he worded it, it wasn't, he didn't necessarily say they had questions. They just wanted more information. So I'm wondering if they're all just like us, well, what else you got? We want to know more. Cause we all want to know more. Or I wonder if it was a real, deal, because to me, it's, they can choose whether to indict or not. It's not like Bryan Kohberger is in the courtroom and they have to physically look at him and they're getting threatened or something to where they're like, yeah, no, we're not going to indict him. They don't know what's going on. You know what I mean? They don't know him from anybody. So indict or not, and they could have just said, no, we don't want to indict those 6 people. But 16 people, all of them collectively said, we want to indict this guy. So I don't think the judge had really, anything he could really even do about it if he wanted to. But Jay Logston is putting up a terrible defense. In my opinion, it's word salad to the extreme. Like you guys said, I've listened to this 3 times and I can comprehend what people are saying. I'm a pretty smart girl, went to school for stuff like this, but this guy's all over the planet. And, the other planets too. So, and I do have some notes that I took after this. I'll read those out for you. Cause I was on a thing on my phone.
Just
it was funny.
Make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. Obviously, we've been talking a bit about how we don't think that that's what occurred. And we certainly don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6 of them wanted to hear more. until they were essentially cut off and told probable cause is the standard and what are people doing?
You probably should cut that, what the grand jurors did or didn't do.
Fair enough, good. But
Fair enough. So see, right there, he said we should probably cut that. Like meaning to me is saying you can't possibly know what those jurors were thinking or weren't thinking. And he said, "True, you got me there, Judge." And then his hands are up like this because he's going to get upset here in a minute, and he's going to divert. And then look at Bill. Bill Thompson's just wondering when band practice starts. He is in a band as well, just like Creighton Waters.
I'm just pointing out that there's clearly prejudice in the record that the court can see from what they were being instructed. It's also, as we argued, clearly going to be fundamental error. You tell the grand jury that this is the standard and it's actually something else. You can't possibly think that the result that you're getting is the accurate one, so you have to do it again. These are fundamental rights that people have, so clearly that would be the way.
Right, but you just agreed that the court and the case law, going back to at least Edmondson, have the standard as probable cause. So, to just say, well, they were given the wrong instruction is not exactly the case. I mean,
This is the D team putting on the Z game.
In Idaho for years, maybe 100 years. It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now I understand the argument between substantive and procedural, and that's that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life because I've spent much of it arguing that things that everyone in the state is doing are wrong.
True.
And occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So
He said rarely, but occasionally, my client sometimes walks out of prison. Did he really say that? I missed that. The first 2 times I listened to this. Did I hear that right? He said, what am I doing with my life? I'm going to go back because am I hearing stuff? I might be hearing stuff, y'all, but I don't think I heard that wrong. Let's just go back a little bit because this is getting funny. He's getting funny now.
And that's, that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life because I've spent much of it arguing that things that everyone in the state is doing are wrong.
True.
And occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So
that's fine. You can make an argument that something should change.
Hold on a second. If we ever needed a picture, if we ever needed a picture of Bryan Kohberger's face, it was at that moment that he said that. Sometimes, maybe every once in a while, it's happened once in law school on a practice test. Turn closed captions on. Okay, I'm gonna go back. Let's do that again because that was funny. Okay, we're going back 1 minute again.
Possibly think that the result that you're getting is the accurate one, so you have to do it again. These are fundamental rights that people have, so clearly
This is too rich.
Right, but you just agreed that the court and the case law, going back to at least Edmondson, have the standard as probable cause. So, to just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years. It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now I understand the argument between substantive and procedural, and that's that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life, because I've spent much of it arguing that things that everyone in the state is doing are wrong.
True.
And occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So
well, that's fine. You can make an argument that something should change, but are you telling me that other places in the state are giving a different instruction, that it should be beyond a reasonable doubt?
What I'm telling the court is that it appears that up until 1980, that was true. And so the Supreme Court enters its rule, sort of has this ruling that talks about that, but nobody's arguing about it because they don't have access to the internet, and nobody has a copy of the field code or what California was up to.
Well, Justin Weisslein argued about it in a dissent in Edmondson.
And we thank him for it, although.
Okay.
If
you
you
can't
go
say
back,
that there hasn't been an argument about it.
Well. No. If you go back and you read what Justice Weisslein did, Justice Weisslein didn't know about the field code. He knew it came out of California. He knew that it meant something different.
I think it's attached on the dissent. Some of that.
No, California.
Oh, those are earlier. Oh, that's the earlier session.
He has the California code, and he has the stuff from the territories. That's what he's got. But he doesn't know. I mean, if you read the field code, which apparently nobody did, except Justice Field in California. If you read it, it literally tells you what it's trying to do. It spells it right out, and you can find it for free on Google Books.
We're in Idaho, Logston, and we're not going on no Google Books.
Where I don't have a copy. I'm not even sure where you find it, but except.
And he said, I don't even know where you can really find it. Okay, you just told us Google Books.
Google Books. You can find this thing, and they had a whole preamble to how they're trying to save the concept of the grand jury. They want it to be better than what it is. They understand people have concerns about it. Let's make it better. And it gets adopted in California, and then we took it from that. And then that's what I think should matter. And the fact that the plain language of the statute is being read by every prosecutor in the state up until the 80s when the Supreme Court finally gets them to stop, because the statute's relatively clear. And so the only person who's pushing back against this are these Idaho Supreme Court justices who don't like it. But there's nobody coming to them and saying, here's a copy of the field code. This is where this all comes from. This was the point. Instead, there's just this concern that who could possibly want such a thing? How would we be safe if our communities are only able to indict people beyond reasonable doubt? It's just too much. It's too high a stake. That's hard to believe given how many of these cases are making it up because they were convicted. There's no reports anywhere that I was able to find that in the state of Idaho, all these prosecutors were mistakenly using beyond reasonable doubt. There's just no indictments going on. Nobody was going to prison. Nobody was getting the death penalty. It was a free-for-all, and we had posses riding around and having to deliver justice because the standard was too high of the grand jury proceeding. But that's not what was occurring. What you had
Kohberger was
was
glaring
a
at him.
well-running system, but you had Supreme Court justices that were not aware of where this stuff was going. If somebody had come to them and said it, we'd have a ruling. But nobody did. In fact, we don't have really any state that's ever done the heavy work of this. You've got the New York Court of Appeals, is about the only one that was aware because it happened there. And they've kind of let it drain away over time. Well, other states can do what they want. They can pass new statutes, their constitutions are older than ours, etc. Our Constitution was written in 1890. So it's going to lock in what the people thought that they had as their law and what they considered to be their standard of due process at that time. And the only history we have is you've got a Supreme Court saying, you don't have that right. You got a bunch of prosecutors, of all people, thinking that we do. And that's what you're looking at. The fact that the rest of the country is off doing other things, I don't think necessarily matters. What matters in terms of the courts has to read plain language of statute. The court has to consider the fact that, at the very least, California knew what it was up to, and that even if the people who wrote our Constitution didn't know what was going on, it doesn't mean that the people who wrote the Idaho revised statutes in 1887 didn't know what they were signing on for. And whether or not they were sitting at the Constitutional Convention isn't something that I put enough effort into to figure that one out. But
I resent that. Our forefathers knew exactly what they were putting into that Constitution when they wrote it. They didn't know we were going to have DNA now, but come on. Be nice to them, Jay. Come on. Now he's just going to be blaming on people that aren't even that have been dead for hundreds of years. It was these guys over here.
I don't think it necessarily answers the question. Anyway, I think the one other thing I wanted to touch on was how, by agreeing with me, the court is able to save the indictment by turning it into a presentment. As a presentment, there's a lot laxer evidentiary rules and everything else. Much of the complaints we would have about it essentially disappear, and the state has its presentment. And as far as I'm told, one of the reasons why we had a grand jury in this case is because in another case I had argued that if you don't do a grand jury, you can't have the death penalty, which I still believe. But if you have a presentment, that's also listed. And so the state still gets what it wants. And we get a preliminary hearing, which it seems to me would be worth the candle for us.
I think there was some instruction about present for the grand jury, was it not? They were given that option.
Well, I think they were told about it. So I don't know. I mean, the court maybe can find it. I can't find a single presentment in the history of Idaho. So I don't know if they've really ever been used.
I don't know.
And I hadn't really even thought about what they are, what they meant until taking up this argument. But from what I could tell, going back to the field code and looking at everything else in the statutes that we have on hand, I mean, essentially it's like grand jury light. Typically for the presentment, the idea for who is getting the presentment seems to come from the grand jury members themselves. They just come in with some information about somebody, they make an accusation like it's a complaint, and then it goes off and it gets treated more like a complaint than it does an indictment. I don't know if the court found anything otherwise. That's the way that it appears to supposed to work. Like I said, I don't know if anybody's ever done one, but I do think that what the state accomplished in the indictment in this proceeding would easily meet the requirements for present. And I don't think we would have any real ability to argue with them. I mean, the grand jury itself can just come in and say, these are some facts I heard from my neighbor, and I think that guy committed a crime, and that's enough to start the wheels of justice. And I'm relatively certain we've met that requirement. And so if the court does that, then the state still has a piece of paper that says the death penalty can be sought in the Fifth Amendment of the United States Constitution. And a preliminary hearing would be offered to give us the ability to take a closer look at this case than what was given at the actual grand jury. So, you know, everybody could win. I do have that as an option for the board. Does the court have any questions? It looks like you might.
I might on your reply.
Okay.
We'll see.
That's it.
Thank you. Mr. Nye?
Thank you, Your Honor. As much as I enjoy the frolic through legislative history, as a trial attorney, we usually have a shortcut. And that is we check to see if the Idaho Supreme Court has ruled on the issue. And in this case, it has multiple times. So in Edmondson, the Supreme Court said, and I quote, "The purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports a finding of probable cause, it is not for an appellate court to set aside the indictment." This court is bound by that holding. The Idaho Supreme Court applied that holding in two subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings. The only other thing I would add is, to summarize Mr. Allison's arguments, Idaho law supports it as long as you ignore the Idaho Supreme Court. California law supports it as long as you ignore the California Supreme Court. Idaho's constitutional history supports it as long as you ignore the founding fathers. I could go on, but there's nothing to see here. The Idaho Supreme Court has ruled on this, and this court is not right. Unless the court has any questions, or something.
Thank you, Mr. Nye.
Thank you.
Okay, Mr. Logston, you want to add anything else?
Well, that's just not what happened. I mean, Judge, courts say things all the time. We call it dicta. When a court is listing off,
Sometimes we call it the law.
sometimes, but what we're talking about when we talk about evidence is we're talking about it. I mean, nobody was arguing in that case that probable cause was the standard. They were arguing over whether or not it's fair that some people get a prelim and some people get a grand jury. That's what that argument was about. And the guy didn't come in and say, "Oh no, I got a grand jury and the standard is beyond a reasonable doubt. But that's too, I don't like that. I'd rather have a prelim with a probable cause standard." That doesn't occur in that case for various, I'm sure, fantastic reasons. And the same thing happens in these later cases. I mean, it gets responded to. And yeah, like I said, the Supreme Court adopted a rule, but it's never tested the constitutionality of its own rule. It's never heard arguments on any of these things. It's not stating a holding after an argument. What it's doing is it's just reviewing what it believes the law to be that nobody's picking a fight about. I'm picking a fight about it.
And you may have the opportunity to do that to this.
Did he say I'm taking a bite out of it? What did he just say and yell? I was in the shower when I was listening to this the first time. No, first time I listened to it here, but I was kind of doing things. The second time I listened to it in the shower. So I missed his body language a lot of it.
It's not stating a holding after an argument. What it's doing is it's just reviewing what it believes the law to be that nobody's picking a fight about. I'm picking a fight about it.
I'm taking a bite out of
You
it.
may have the opportunity to do that to the Supreme Court.
Well,
I mean, that's what you're
And
building.
if
That's what you're building for.
if
Because
that's-
you know that I am constrained by existing law. I can't just change the law as a trial court if it's established. And I would say that in Edmondson, there wasn't an argument because it was settled law. I mean, I think that's really the problem. So, of course, a lot happened from 1880, 1890 to now, but the law doesn't always just sit still. I mean, it evolves, and that may be just what happened naturally. I don't agree that the language of the statute is completely clear too. I mean, I think you can interpret it different ways, and a lot of people have interpreted that language different ways. Whether it's beyond a reasonable doubt or a probable cause. And you can argue with me about that. I mean, I'm kind of baiting you about that. So,
Judge, the cases that say that are very self-serving. These are courts that are essentially openly hostile to the idea of using a beyond reasonable doubt standard. And so they make claims like to warrant really means to permit the trial jury to see it. That's not the wording of this statute. The California case gets written in the backdrop of a statute being passed in the 1940s that says probable cause is what you're going to look at when you're deciding whether or not these indictments should stand. So it really doesn't, whether or not the grand jury is being told something else to some extent turns into a moot point. The reality is, just because the courts didn't like what the legislature had adopted, and in our case, unlike California, unlike New York, but what was part of the concept of due process in our Constitution was written, just because the Supreme Court doesn't like it, doesn't mean it's somehow settled law because it refuses to follow it. It has to actually have a case and determine it. Now, occasionally, they can pass rules like they did. So that's where this whole question of whether or not this is a substantive right and a procedural right. But they never ruled on it. And Your Honor has the ability to look at the whole mess, the totality, and say, what is the law? What was the law in 1890? And when did it change? I don't think what the court can write is an opinion that says, well, we don't know when or how it changed, but by 1890, clearly the probable cause was the same in the state law.
Mm-hmm.
There has to be something where the Supreme Court considers these things in order for it to be settled law in a way that in which Your Honor would be right and say, I can't do anything about it. They've never settled this question because nobody ever brought it up. Because it's really hard to get a copy of the field code in 1913. Well, I don't know. But
there was, I can't remember the name right at the moment, but in 1950s, there was dicta where the appellate judge said, no, that's not the standard because they were using beyond a reasonable doubt in that case. Anyway, there was a discussion in that case about what the standard of proof is or should be in the grand jury. So there have been touches of that along the way, I think, but you're right. There's not a whole lot of law until maybe Edmondson that was pretty clear, and then as Mr. Nye pointed out, a couple of decisions after that. That case, I think was 1987, something like that. So, yeah, I mean, I appreciate your argument. It's interesting.
So basically, this has been a law since before Kohberger was even born. They can't change laws after Bryan's been, oh my Lord, let's just change them all now. But this is from before he was even born.
I'm
He was born like 90, I think.
Back to that.
92, 93? I don't know for sure.
You're making your record. That's good.
94.
Cabinet decision held some things. It's true. But he was arguing about that standard of proof. The fact that they stated while they're walking through what a grand jury is versus what a preliminary hearing is, that doesn't settle what the standard is. Just because they said it doesn't make it the law. I think their jurisdiction is limited, and yet broader than the United States Supreme Court, although if you read that most recent opinion where Judge Stegner doesn't agree with any of them about what their jurisdiction is like, it gets kind of complicated. But the point is, they can't just say in an opinion where nobody's arguing anything, oh, and by the way, the law of the land is this. Nobody briefed this issue in essence. Nobody briefed it in any of the cases that came after it. They didn't set in stone via that opinion what the standard is. They tried by adopting the rule. The rule is the question. The court has to try to figure out, is it a procedural right or a substantive right? If the court says it's a procedural right, and essentially what the court is saying is that the courts get to decide how much it takes for one of us to be thrown in the lockup, put to death, etc. Which I can't find any case that has ever said that. They've all said that the standards being set by the Constitution or the legislature, setting these standards over and over and over again. So for the Idaho Supreme Court to issue a rule setting the standard of proof, even though there is a statute that says otherwise, they can't do that. That didn't become something that, I mean, they did it, but the court is in a position to consider whether or not they could do it. The court can tell the Idaho Supreme Court this rule isn't constitutional. Courts can do that. I mean, we consider bail issues. We consider bail on appeal, things like that. Statute versus procedural rights. Those things occur. And the lower court can look at that like anybody else can. Who's in the right? Is it the legislature or is it the court? So I think the court can decide all these things. But if the court's going to say it can't, I hope you'll at least write a 32-page order in which you explain how right I am about everything except that. Thank you.
I'll work on that. Thank you. I
The way he slapped, hold on.
I got the same one, Jay. Look.
Oh my gosh, send me to Idaho, guys. Look. I have the same one as him. It's black and everything. He was like this. Otto says, Tanya, I love when you start laughing. I can't help it. I'm glad you love it because I can't help it. I got to laugh when I can. I'm going to go back to, I want to see him shut that book again. Thank you, he said.
That. I mean, we consider bail
Mine's nicer.
issues. We consider bail on appeal, things like that. Statute versus procedural rights. Those things occur. And the lower court can look at that like anybody else can. Who's in the right? Is it the legislature or is it the court? So I think the court can decide all these things. But if the court's going to say it can't, I hope you'll at least write a 32-page order in which you explain how right I am about everything except that. Thank you.
I'll work on that. Thank you.
He said how
I
right I am.
appreciate the argument. I think it's really creative. And I appreciate the journey back through history. I think it is an important factor in determining what the law is and why the law was established the way it was. But even you, okay, and I've heard this, but even in your brief, and this is your quote, okay, that the whole of modern jurisprudence on the issue is against it, as well as the least one founding father of this state. So I get it. I mean, what it comes down to me is that I am constrained by what I believe is settled law in Idaho. I may be wrong, but this is certainly an issue that you would have to bring up with a higher court, like the Idaho Supreme Court. And I look forward to, getting that from your perspective settled in Idaho. We'll see. There's the rule, of course, which is, we've talked about. But this argument really is fighting against some case law, too. You may say that it's all dicta. I mean, that's debatable, I suppose. But the Idaho criminal rules, specifically Rule 6.5A, expressly states that probable cause is the standard, not beyond a reasonable doubt, and for a grand jury's indictment. And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion and the argument. So I am going to deny that argument. I think the argument is good, but I can't go that far. Not today. I'll give you a written decision. I can't guarantee it's going to be 32 pages. It might be longer. It might be shorter. So we'll see. But it's always enjoyable to have an argument with you, Mr. Logston. So I think that's all we have to do still. Ms. Taylor?
That's it for today, Your Honor.
Okay, and Mr. Thompson?
Yes, sir. We're done for today.
Okay, nothing else to address then. Okay, well, I hope you all got a touch of Idaho history and the law and how it works and our Idaho and
Kohberger
United
looks
States
pissed.
Constitution. So
He is.
go out and learn some more. Okay?
He mad. He mad. It is 32 pages because one of the documents that he put out, that must be the one that I was going to read it tomorrow and do a live over, because one of them is 32 pages. It's all about the IGG. Oh man, that's going to be a good read. Great. But I wanted to see what this order was. Oh, that's not for Kohberger. Okay, never mind. I was like, an order? I'm looking on the wrong person. I'm looking under Chad Daybell. I thought I was under Bryan because I was going to just double check to make sure that nothing came out as we were talking on the live tonight. But yeah, that was a lot of that was a long history lesson. So I had some notes. Let's see here. Okay, so if the defense is saying that they want a preliminary hearing, that's what they want out of this. They want the grand jury to be thrown out and they want a preliminary hearing. What is the difference in a preliminary hearing, them getting the preliminary hearing, or just going to trial? They have all the time that they need. Pretty much right now, it's not, because it's to be determined, trial and I just feel like if they had a preliminary hearing, they would have a deadline. And when that deadline came, they would say, oh, no, we need more time. Because that's what we've heard this whole time. Let's see. Also, if the prosecution had anything that Bryan Kohberger's defense team needed, I'm sure that the prosecution would have given it over by now, because they have put in discovery request in after discovery request. The judge is not going to just let them do all these discovery requests if he knows that the prosecution has something. So they keep saying that the prosecutor has this exculpatory evidence that's going to get Bryan Kohberger off. Well, then tell the prosecutor what that exculpatory evidence is so he can go grab it for you. But you don't have that. You don't know what it is. Ann Taylor, there's nothing there. She's like, just, I don't know, picking at the air. So she's just going to keep saying it. But it's like, come on, Ann. Come on, Ann. She should have never let Jay take the reins on that one. She should have stood up and did that talking, because she's very... I think that she's a pretty good public speaker. Like, for the most part, she has confidence, and when she speaks, and I feel like that would have been a lot better for him than Jay Logston. It looked like he was kind of upset with Jay at the end. Like, he was like looking like, I gotta go back to jail. But it doesn't look like it's just the order addressing the IgG and from the DNA, and we'll go through that tomorrow. And that's because that's 32 pages. That's a long document in order for camera review. So, yeah, I'll have to read through that tomorrow. What else was there? Anything else? Oh, and they were saying, that people had questions. Well, I mean, if they did, they didn't say that they had questions. They wanted to hear more about the case. So I'm wondering if they were just curious and they wanted to know more about the case, or if, because I mean, they weren't going to not indict him. They didn't have to indict him. They didn't have to say yes on their little jury ticket. They could say, nope, don't want to indict. And if there was 6 people, then 6 out of 16, that's a good amount. If you had that much conviction that you didn't think that he did this, you would stick to your guns, I would feel like. But I don't know. I've been on the jury before and I would stick to my guns. I did. Me and this woman was having it out. we were like, it was crazy. All they were hearing was probable cause. Yeah. Maybe by demanding imaginary exculpatory evidence, it'll manifest itself. Ashley said, I know, Roseanne. And then his alibi. If he could even produce a better alibi, even if it was, I don't know what I was doing, that's better than driving around. Because she says he started driving around on November 12th. And we know he was on camera at 5:27 going back into Pullman. So it's like, you were driving from around between 11 and 12, because that's the 12th, through 5:30 in the morning. Who drives for that long without stopping for a pee break or getting gas, getting food? I don't know. I would do something. So, welcome, Ms. King Scarlet. I thought it had to be all 16. I thought it had to be unanimous. Let me know. I thought it had to be all 16. Yeah, I think all 16. I'm typing this in so bad. Like, I hope that Google is, Okay, let me see. It says it consists of 16 qualified jurors of the county in which the grand jury sits, but 12 or more members constitute a quorum. Let's see. We read through this before. What's a quorum mean? I don't know what that means. I'm sorry. We're gonna have to look that up. Does anyone know what that means? Quorum? I'm probably saying it wrong. The minimum number, you're members of an assembly or society that must be present at any of its meetings to make the proceedings of that meeting valid. So I think it's 12 to 16 jurors sit on the jury. But I think that he had 16. He can drive all night because he's a zombie. And then plus, what about his visual snow? How can he drive with the visual snow problem? Because we pulled that up, and that's a problem. If you have visual snow, even if you were just to have that on a rare occasion, you wouldn't catch me driving. And I have one eye. I drive with one eye. But I'm good at driving. Vincent says I'm not good, but I am. No, so just all 16, so all 16 agreed, but people are saying like online right now that six jurors had questions, but that's not what Jay Logston said. He said they wanted more information, and then the judge said, well, we have to cut that. You can't possibly know what they were thinking. And he's like, yeah, you're right. But nobody listened to the full clip. And then the internet kind of broke there for a little while. I've seen it everywhere. And it's crazy because I've seen one person say it, and then other people just take that person's word for word and then put it on all these social media platforms. I'm like, what is going on? It's like, you're not even watching the video, guys. Watch the video with us. Come over and watch it with us. But that is all I have for you guys today. We had a long day together, but I'll be back tomorrow. We were going to do, I think, an afternoonish, not afternoon, but I think we might do around 4 or 5:15 tomorrow live. But if not, we'll do tomorrow night. And then we'll get back on our nightly lives. We just had a lot going on. So That's true, King Scarlet. He diagnosed himself. That's true. But yeah, that's all I have for you guys tonight. Thank you guys so much for coming and hanging out with me. I appreciate it. If you guys didn't get to see the live from earlier, we did do a live covering the Maine shooter out of Maine, mass shooting out of Maine. I don't think they've caught him yet. I haven't heard anything, but I don't have the TV on. And you guys haven't said anything in the chat, so I don't think they've caught him. That's crazy. So we will have to make sure that we do a live over that tomorrow too. So, oh, thank you, Wist. I think it's called Thunder Gray. Thunder Gray. I'm pretty sure that's what it's called. I have to figure that out again. I told someone the other night and then I forget, but I think that's what it was. Thunder Gray. I appreciate it. But thank you guys all so much for coming and hanging out with me. If you don't mind just hitting the like button on the way out, subscribe to the channel, all that fun stuff. And I love you guys. I'll see you guys all tomorrow.